When we talk about witness, we essentially are discussing ourselves because we are witnesses to different events in life, isn't it? Uh, Albeit we are not always put under an examination. When it comes to litigation, trial court is the first court where litigant seeks relief, isn't it? When a litigant comes to you and wants to uh, redress his grievance, the first court is trial court, and a witness is examined before a trial court. Thus, even in this context, today's topic is important, considering that the examination of witness has direct impact on redressal of a particular grievance. The remedy sought by the litigant who comes to you, that redress is to be the redress of the grievance is before the trial court. So, who will tell me what do you understand by witness, or who is a witness? Witnesses, like I explained, we also are a witness to different events. But now, from the perspective of litigation, who, according to you, is a witness? So, who is a witness? A person who has sensed something relevant. Good. So, when we say relevant, we talk about relevant fact. There is whole series of sections on relevancy in the Evidence Act. Okay, so there is a philosopher by name Bentham. Must have heard of him in your law studies. So Bentham says that a witness is eyes and ears of justice. So much importance is given to the witness because he is regarded as eyes and ears of justice. So what Mr. Athole said is correct. A person who has sensed something relevant. What are characteristics of a witness? And because before we delve into examining a witness, we have to understand a witness, isn't it? So what are the characteristics of witness? What could be the characteristics? His age, his occupation, his education, his background, as in what work he does, his family background. For example, why is it important to consider age of witness while examining? Maturity, experience, expertise, then qualities which a person by his age evolves. A lawyer should be conscious of the age of the person he is putting question to, isn't it? An aged person, for example, may need help with memory. He may not recollect facts. So the lawyer must be putting questions in such a way that it would help the memory of this aged person. A young man, a youth, may need some extra guidance to answer questions as well. Like often a child witness, if you see, requires more care while examining. He is vulnerable, and in fact, there are guidelines also issued from time to time by courts in regards to child witness. So there is one case, if you want, you may note down. Smruti Tukaram Badade versus State of Maharashtra. Uh, it is age impact senses like eyesight, hearing, correct. Absolutely. So it is most difficult task to get depositions from child witness also. A child witness may be under fear, shock, or if he is a witness to some grievous crime, it could be a very disturbing thing for him. There is likelihood of tutoring also by his relatives, by his parents. So hence age is important. Then demography also could be an important factor. Don't you feel so? Isn't it? It is always better to question a witness in his language and style. If he is from a rural area, talking to him in his tone and tenor will make the communication easier and fruitful. There is more context to know what region the witness comes from. because there are certain biases also in witnesses. We are all humans. Witness is a human ultimately. So he will come with some biases and prejudices. For example, if a witness is born and brought up in a region which is often hit by droughts, okay, like region of Marathwada in Maharashtra, there is likelihood that such witness may have anti-establishment sentiments. A witness may have prejudice against people belonging to a particular demography. For example, in Mumbai, we all see it is common knowledge that local Marathi people may have negative sentiments towards migrants from north. So all these things we have to, as lawyers, understand. So because a witness is a human being, he will have different prejudices. Even residents from two villages, if you notice, have grudges against one another. In India, it is not uncommon where villagers discourage inter-village marriages also. Sometimes we see boycott of couples if they had married inter-village. A judge must not be oblivious of all such context. So, from a judge's perspective, also it is important to be conscious of this fact that some prejudice may be caused, and biases there may be biases exist in the deposition. Likewise, so age, demography, then education. Education also is a relevant factor, a relevant characteristic, isn't it? If a witness is testifying that he signed Panchanama, okay, which is in Tamil language, and his entire schooling was done in Hindi, it will become a relevant fact that whether he can read Tamil at all, if his entire schooling is done in Hindi. Further, you must have heard that a person's character can be judged from the company he keeps. While one must not draw, strict inferences from such backgrounds of a person, but a general idea about person's upbringing can be known. For example, knowing family background or occupation of the family of the person would allow a lawyer to prepare the question suitably. If you are examining a witness who is teacher by profession, chances are that you will get a detailed explanation for your questions put in examination. On the other hand, say you are examining an accountant, it is more likely that he will have an organized and clear memory about things. So, knowledge of witnesses' occupation helps from the point of view of the style in which you ask questions. So, that is how this characteristic of witness is important. Who can appear as a witness? Any human being can appear as a witness. Okay. There are two main qualifications which is given under, I suppose, 118 of Evidence Act. Ability to understand question and ability to give a rational answer. So if these two abilities are there, he can be a witness. So the special categories of witnesses that may be understood are persons of unsound mind and of tender age. Okay, so when this question is who can appear, so these are the special categories also. So we will discuss on this, but on a broader note, ability to understand a given question and to give a rational answer. So if these two abilities are there, he can be a witness. Okay, and you don't appear as a witness, you are summoned as a witness. You are summoned before the court. Okay, the lawyer appears before the. So another case you may note down is Zahira Habibullah Sheikh and another versus state of Gujarat. So this is with respect to role of a judge and a lawyer in deciding cases with respect to unsound mind of witness. Okay. So the special, so I have mentioned the special categories. So these are the special categories of witnesses, unsound mind. Now, since you have asked this question, another aspect is when a witness is not able to speak. Can he be a witness if he is not able to speak? Anyone? If a person is not able to speak, still can he be a witness? I suppose there was some movie also on this. I don't recollect, but there was a movie on this. I suppose. Yes. Amol says yes. He's right. So when a person is not able to speak but wants to give evidence, in such scenario, there is a section 119 in Evidence Act which allows the witness to give evidence. And then can accused be a witness? If we talk in terms of criminal trial, then can accused be a witness? Accused cannot be a witness.
So Payal is saying no.
So yes, that's what. Anyone who says yes?
Jigar sir is saying
Jigar
yes.
says yes. Okay, can you supply some reasoning for no?
Sir, as per the law, witness cannot be forced to be a witness of his own crime. This is some law under the section. So, though he
Correct.
has committed the crime, he is not bounded to be a witness of his own crime.
Yeah, but that doesn't mean that he cannot be a witness. Okay. So yes, Mr. Rathole also says self-incrimination, which is what Ms. Payal was exactly pointing out. You are absolutely right, Ms. Payal. So self-incrimination. So you cannot be asked to be witness in your own case. That is also one aspect. So it must be borne in mind that accused cannot be compelled to be a witness. So Article 20 of the Constitution, which protects an accused from testifying against himself. It is only if he volunteers to give evidence he can become a witness. He wants to explain something in his defense, then he can come before the court. So after typically the 313 statement, who are lawyers who regularly practice would know 313 stage statement under 313. So the judge may allow the accused to be a witness. So I take it by now we have understood the meaning of witness, the characteristics of witness. Yeah, Jigar says in conspiracy, one of them can be a witness. But then there is a separate line of approver, etc., etc. That is a another aspect. But for now, we have in a broader way understood what is the meaning of witness, what are the characteristics of witness. Okay, which is pertinent for the examination of witness. So, what are the types of examination? It's very common. It is examination in chief, cross examination, and then re examination, okay, which is optional. Let's understand in the same sequence what is examination in chief, what is its purpose. So, examination in chief is for deposition of facts of the case, which either the witness, if the witness himself has filed, he will depose, or he has given statement supporting the case of someone, he may depose that, or he may be connected in some way or the other with the case. So, like an expert, he may be connected with that case. So, he also can be deposing as a witness in examination in chief, which will have impact on the trial. So, it is opportunity for the witness during the examination in chief to put facts that he and the party examining him believes to be true. Okay, so in examination in chief, what does the witness do? He puts the facts that he and the party examining him believes to be true before the court. Now, the prosecution gets the first opportunity to conduct examination in chief of its witnesses, to bring before the facts, bring before the court the facts as per section 138 of the Evidence Act. It provides for the order of examination. So, examination in chief is conducted in usually in question and answer form. That is very common. You all must be knowing. You must have seen in courts how it is conducted, and then the facts so elicited must be relevant. So, I think Mr. Athole mentioned in the beginning about a person who has sensed something relevant. So the facts so elicited from the witness must be relevant. Now, evidence must be given about the existence or non-existence of facts. Okay, so existence, that a fact exists also, so the witness can be put questions regarding existence of a fact and non-existence of the fact, and those facts, such facts should be in issue, and other facts which are relevant. So this relevancy of facts is, you will find from section 5 onwards till I suppose 50 or 55 of Evidence Act. Okay. So while examining a witness, you should be clear about the concepts. Apart from this relevancy of facts, you should be clear about some more concepts of presumption and burden of proof. Now, there are sections that provide for various presumptions in evidence, and so also there are sections which talk about burden of proof. Now, why I say that one should be aware about presumptions and burden of proof while examining a witness is because if a lawyer wants to invoke a presumption, he will have to accordingly ask questions to the witness, creating foundation. Okay, if he wants to invoke some presumption, he will have to create a foundation. So also, if you want to discharge a burden of proof, okay, so burden is on you, you are litigant, and you want to discharge that burden of proof, then the question will have to be framed in such a way that the relevant fact discharging the burden of proof comes out in the deposition of the witness. Let me explain you with an illustration. For example, say this Jigar murdered Payal, and the weapon used, say, was sword. Sword was recovered under a panchanama from residence of Jigar. Then the recovery of the sword from Jigar's residence would be a relevant fact, and burden of proving this fact will be on prosecution. How will prosecution discharge this burden? By examining a punch witness in whose presence the sword was recovered, isn't it? Look, for examination of a witness, you must know these concepts of law. That is the evidence law, that is burden of proof, presumptions, etc. So section 4 of Indian Evidence Act explains may presume, shall presume, and conclusive proof, etc. Now, to facilitate running of presumption in favor of the prosecution or the party examining in chief, as the case may be, the lawyer must ask questions that would invoke presumption of fact in favor of the prosecution. So this is how one has to approach when one has to conduct examination in chief. Now, here is a short, there is some question. Is there book? I don't know whether there is book titled as Presumptions in Law. Must be. Not here, there is a short, I will tell you in short what one must keep in mind while examining a witness in chief. One thing is you have to, it's kind of checklist I will give you. One thing is that you have to ensure that your story is on record. Okay, the story which you want the witness to narrate, that comes on record. Secondly, if you have got some material like document, then there is sufficient material you have brought on record through the witness, because another use of examination in chief is to prove certain document or prove material. How will you prove panchanama of recovery of that sword from Jigar's residence? By examining the punch witness, and the punch witness will say, yes, I have signed this panchanama. So proving document. Then you have to also ensure that you have plugged potential questions that would be put in cross examination. Now, this is something which you learn by practicing in courts actually. So you anticipate certain questions that would be put in cross examination, and you ask questions in examination in chief in such a manner that the witness answers in a particular way where the cross examiner will also find it difficult to locate any lacuna. Then you have to also see that are all the witnesses that you were supposed to examine are examined. Okay, because during the investigation there will be a number of witnesses. It is not necessary that all the witnesses which form a part of the charge sheet in the list of witnesses need to be examined. It is not compulsory. You have to, as a prosecutor, choose which witnesses are to be examined. Just because you have many witnesses doesn't mean that every witness needs to be examined. So examining chief is meant to basically proving facts that are relevant to the case, placing the prosecution version on record, that is the story of the prosecution, introducing any document or material in the evidence, then important is establishing the role of the witness and his credibility. That is also important. So why it is important? Because the court should believe the witness. Now, after the examination in chief is done, does it mean that the test of truthfulness is done? It doesn't. So examination in chief gives you all this story, the material, documents, credibility of witness. But what about the truthfulness? The truthfulness is tested in the cross examination. So this testing is done by putting to the witness question for the purpose of doubting, opposing, and discrediting the theory which the witness or rather the prosecution is trying to establish through the witness. Okay, so the nature of the questions often is such that would put stress on the witness to elicit truth. The whole exercise is the exercise of cross examination is to bring truth before the court. So the effort of a defense lawyer cross examining a witness is threefold. Okay, one is to prove that the story deposed by the witness is false. Second is to create enough doubt to make the testimony of such witness unreliable for conviction. And third is to build a defense for acquittal. Okay, I will repeat it. One objective is to prove that the story deposed by the witness is false. Second is to create enough doubt to make the testimony of such witness unreliable. And third is to build a defense for acquittal. Okay, so unlike in examination in chief, leading questions are allowed to be put to the witness while cross-examining. So in examination in chief, leading questions are not allowed. What are leading questions? Yes or no question. Have you quit smoking? Okay, what will you answer to this? If you say yes, that means you used to smoke. If you say no, that means you still continue to smoke. So the witness can even be suggested with a fact or theory for the witness to admit or deny the fact or theory. So suggestions are also some important part of cross-examination. And one has to remember cross-examination is also known as a procedural right of an accused in criminal trial. It is a powerful tool in the Indian trial system to reach a correct verdict. As I mentioned earlier, it is truth. We are testing the truthfulness of the prosecution's story. It is also based on the principle of natural justice. So an adverse party gets the opportunity to challenge the credibility, consistency, and the reliability of the witnesses. So in India, because we have a adversarial legal framework. Okay, so it is very effective. Now, for effective cross-examination, a defense lawyer must have certain factors in his mind. What are those? First is you have to identify your defense. What defense are you going to come up with? Never ask questions by shooting in dark. Be sure about the answer of the question you are going to ask. Don't ask questions in cross-examination of answers you don't know. Okay, so this is very important. Study and observe the witness well. You have to create foundation for the case which you are trying to build to challenge prosecution's case. Those foundation can be built by putting suggestions. Do not end up challenging each and everything which the witness is saying. Okay, that doesn't mean ki whatever witness is saying, you have to say ki this what are you saying is correct, this what are you saying is correct. No, be conscious that some facts established by the witness may be in your favor also. Okay, so witness is not your enemy. Please remember that. Admissions because brought through cross examination have a higher value than admissions brought under examination in chief. So remember that. So be conscious of what you are going to ask. It is not compulsory that cross examination must be conducted. Okay, I will come to that. So cross examination is also an optional thing. People feel that cross examination we have to compulsorily conduct. It is not like that. So do not consider witness as your enemy. Be aware of the ethical boundaries also while putting questions. So there are certain sections in Evidence Act which prompt at this particular scene also. So there is a question, many times we may not get all details from the prosecution in discovery. So how can we generate effective questionnaire? Any tips, please? So if can a complainant be witness of his own criminal case? Complainant has to be witness. Complainant has to be witness, no doubt about it. He has to step in witness box unless he is a victim and he is dead. So if there is a dying declaration, then obviously he cannot be, which is also an exception to hearsay evidence. There is something called as hearsay evidence. So unless a victim has died, first witness of the case. What first witness of the case? Create some foundation for your question. Okay, so I will understand first witness of the case. Anyways, I will continue and then reflect upon these things. So in all, cross examination protects the rights of the accused. Okay, it is for the procedural fairness and to uphold the constitutional values of fair trial under Article 21 for that matter. It demands a lot of skill, preparation. Okay, now I had mentioned that it is not compulsory to cross examine. So I will narrate an incident. What had happened was there was a case where a witness deposed. She was neighbor. She was not the complainant, but she was purportedly a witness. So she deposed that I have been residing in so and so area with my family for last so and so years, and A and B were married for several months, and they were residing next door neighbor. They were my next door neighbors. Now the wife used to talk with me. I am narrating what the witness is. So witness stated that the wife used to talk to me, and she used to tell me that her husband had demanded dowry from her, and he would quarrel with her, etc., etc. And one day, on that is on the day of the incident, I was making tea in my house, and suddenly I heard sound, "Bachao, bachao." Okay, help, help, and "Bachao, bachao, aag lag gayi." And hearing this sound, I came out from my house. I saw that there was smoke coming from the next door, and I opened the room. I barged in the room. It was locked, so I had to push the door, and then other people also came to help me. And then I opened the door. Somehow I broke into that room, and there I saw this wife burning. Her clothes were burned, and the there was a bucket of water. People tried to put that water on her to extinguish the fire, etc. And while describing the victim, this particular witness said that her mouth was gagged. Okay, now on basis of this narration by the witness, the lawyer of the accused chose not to cross examine her. Okay, if you have followed this particular narration, will you be able to tell me why this particular lawyer for the accused chose not to cross examine her? As I told you, cross examining is not compulsory. So I will only tell you, she mentioned that she heard "bachao, bachao," help, help, and at the end, while describing the she was gagged. How can she shout? Exactly. So, in her deposition, in examination in chief itself, there was such a big contradiction. Okay. Therefore, the lawyer for the accused chose not to cross-examine her at all. And during the course of arguments, this point this point was raised. You see, and therefore there was no need of cross-examination because that witness itself is not credible. That testimony of witness itself becomes doubtful with such kind of deposition. So this is how one has to be very vigilant while conducting the trial. So not necessary that you should always cross-examine a witness. So we all know that there are delays also in trial, correct? So this now I am not explaining about the cross examination. Now we have an idea of cross examination. So there are like 3-4 years down the line, the witness has to come and narrate incident of what he saw then. So is it fair to remember everything? Certainly not. So there is one section, I don't recollect, it is some section 160 or one, I don't really recollect the number of the section, but it gives an option to refresh memory. Okay. He may do so by, the lawyer may do so by, the witness may do so by referring to certain documents or writings to revive the recollection of the facts. But, though the object of this refreshing of memory is to ensure that the facts are accurate and the testimony is accurate, but such refreshing of memory must be done before the court only. Okay. So there was a case in the Bombay High Court where the punched witness in his deposition had admitted that police had read over his statement to him and also told him to tender evidence as per his statement. He admitted that he was giving evidence as per the as per his police statement. Now, it was contended by the prosecution that this incident has taken place 9 years ago. So there was nothing wrong if the witness was refreshing his memory. But the High Court, what it opined is that there would be indeed nothing wrong in the witness refreshing such memory, but that ought to be done before the court and not outside the court. Okay. So, the logic behind the provision for refreshing memory is to balance the human limitation as against the cause of justice. Human limitation with respect to memory as against the cause of justice. So, the reference to writing, contemporaneous writings are allowed to be inspected by the adverse party also if the witness refers to such writing. Furthermore, if a witness refers to a document for refreshing the memory, the adverse party can even cross-examine the witness over such writings or documents which the witness refers to. Now, we have done examination in chief, cross-examination. Now, what is re-examination? Okay, as I told you that cross-examination though is not compulsory, though in general it is a practice to conduct cross-examination. A re-examination is only in exceptional circumstances. It has to be done with permission of the court. So it is not any right. Like cross-examination is a right. Though it is optional, it is a right. A re-examination is not only not as such optional, but it has to be done only if some explanation is required to be given. Okay. So when a witness has given certain facts which are not which need explanation, then and if the court is satisfied that these facts need further explanation, only then the witness can be re-examined. So under ordinary circumstances, it is not necessary or permissible to allow a witness to be examined once again. Okay. But re-examination can be used as a clarificatory tool. The intent is to safeguard the testimony, the integrity of that testimony, and the trial's fairness. It should not be misunderstood to be a tool to reconstruct the testimony of them. Okay, so there cannot be a new version altogether to the testimony of witness. It can't be a reconstruction. If something is omitted in the testimony of witness, it can't be filled through re-examination. That is not allowed. Okay. So now we have understood who is witness, then the characteristics of witness, and examination in chief, cross-examination, re-examination. Now, how does one approach deposition? Actual, this is something we will discuss on that. The actual examining the witness to get the depositions from there is no structured mechanism to do so. Nowhere it is like no rule prescribes it or no statute prescribes it, but you have to keep certain things in mind while examining. That is, in short, I will tell, and I will conclude. One is to be very respectful. Okay, so see, please, you have to understand, court is not a very happy place to be for any person. So witness is no different. Okay, so the court never has a very comfortable atmosphere. If you are polite and warm with the witness, it will relax nerves of the witness, and you will get the answers what you want. Especially by in conducting examination in chief, which is more difficult than cross-examination, because while conducting examination in chief, you have to get your story through the witness. So the witnesses are usually nervous, and because of the court's atmosphere. Therefore, there is likelihood of bad tempers, raised voices. So the lawyer should not engage or entangle into personal debates and disputes with the witness. Don't get personal. Then another thing is, how will you address witness? You should address them as sir, madam, or if it is in local language, you can say janab, sahab. Okay, or if you are taking her name, don't say Ramesh, say Ramesh ji. Okay, so these are some basic etiquettes you should keep in mind while examining the witness. A good lawyer will always try to develop a good rapport with the witness during the course of deposition. So if the witness feels comfortable, then it will depose he or she will depose in a comfortable manner. Then there is no sequence also of putting questions. But with respect to sequence, I will try to just share my experience. Generally, we prepare series of questions to be asked in sequence of events that have occurred. Okay, so we read the complaint and accordingly we decide our questions, whether it be while preparing for examination in chief or while conducting cross-examination. While conducting examination in chief, it is naturally advisable to ask questions in sequence. And this is a good and easy practice because it helps the story to have a particular flow. Now, if the advocate shuffles the questions in contrast to the sequence of events, the witness may lose the track. So, therefore, one should be very conscious of this while conducting examination in chief. But when you are conducting cross-examination, it is not necessary that you should follow a sequence. In fact, you should try to break the sequence in which the witness is thinking, because witnesses usually think if they are coached, and this is the quality of the lawyer who can break the witness's sequence and bring before the court that he is a coached witness. So, for instance, the witness might have deposed a particular event in examination in chief, and there was an omission. Now, such omission at the instance of a witness might be helpful for the case of the defendant or accused. Yet, in just because question was prepared, the advocate might put a question. So, in the examination in chief, a particular fact was omitted. But because as a defense lawyer, you have prepared your question in a sequence, You keep asking those questions, and then the omitted fact comes before the court in cross examination. Now, I have told you in the beginning that admission in a cross examination stands at a higher pedestal. Now, by committing such error, you actually have let the trial go in different direction, because this omission would have been in your favor, and by committing such mistake of asking questions in a particular sequence without realizing that the witness had omitted this particular part in his examination in chief. So one has to be very conscious. For instance, an eyewitness mentions in his police statement narrating the incident of murder that, say, Jigar had stabbed Payal, and while Payal was trying to recover from the assault from Jigar, she was shot with a revolver by Jigar. Now, during examination in chief, the witness does not mention that Payal was stabbed with knife, and just says that he or she, that is the witness, saw Jigar shot Payal with revolver. The lawyer for defense had prepared a series of questions, and one of the questions to be put to the witness was regarding kitchen knife, to bring out the contradiction, because that knife was recovered in Panchanama. Now, without following the sequence of events of the case established in the examination in chief, the defense lawyer puts the question to the witness: is it correct to say that knife which you saw in the kitchen, it was a kitchen knife and not a clever knife? Okay. Now, this question would invite deposition of knife which otherwise did not exist. So, in the examination in chief, there was no mention of knife. There was only mention of revolver. The knife got introduced in cross examination. Why? Because of the mistake of the lawyer. The lawyer prepared his cross examination by going through the police statement and prepared his line of questioning based on police statement. But he forgot that the witness had in fact omitted this factor of knife. The Jigar, they never used knife, but the lawyer of the accused, that is Jigar's lawyer, invited his trouble to Jigar that the knife was used. So this is very important fine aspects which need to be kept in mind while cross-examining witness. So gathering feedback is also important. What do you mean by gathering feedback? How are the expressions of the witness? Confident, nervous? Also, what are the answers in your cross-examination? Because such feedbacks would allow the lawyer to restructure the questions if needed. He may curtail his questions if needed. He will even elongate his questions if needed. Okay, so therefore, these are also important aspects. Framing of questions is also important. I have said, have you quit smoking? Have you left smoking? It's a yes or no question. That means you used to smoke. That is how you ask leading questions. Now, while framing question, one must also keep in mind what answer is to be expected. I have already mentioned that never ask questions of which answers you do not know. That slide may be shown. See, these are, just read these facts. So these are relevant facts in a case. Okay, comprehend them. Now let us move to the next slide. See, this is corroboration. So as a prosecutor, while examining the witness in chief, your intention should be to connect these facts. Possession of pistol by Mr. Sharma, cartridge is from the same pistol recovered. Now, I will explain one by one. This cartridge is from the same pistol recovered. Who will be able to verify this? An expert witness. Okay. Then you have to also ballistic forensics, correct. Then Ram Prasad killed Bhavani Shankar. Presence of Mr. Sharma at the spot of Mr. Sharma threatening Mr. Bhavani Shankar and possession. So these are all connected facts which will have to be established through different witnesses. Punch witness will be required for proving the recovery of pistol, etc., etc. And as a defense lawyer, while cross-examining, you have to try and break this chain of events, this corroboration. Okay. So while preparing for any case, this is the right approach to prepare. Actually, there are many things to get into, like the expert witness. We can talk a lot about expert witness, about hostile witness, different types of witnesses. Basically, there is a lot to talk about it. There are any questions here, I will
Yes, sir.
say.
Yes, sir.
I don't know whether there is any book on presumption in law, but I have authored one book, Stages in Criminal Trial, that I can tell you. Can a complainant be a witness? Yes. In his own case, yes. First witness of the case, sure. This I did not get a first witness of the case. So there is nothing else.
Sir, actually, today's session was regarding the criminal offenses and the examine chief witness regarding the criminal cases. But
Ah,
in few civil cases, I have seen
ah.
there are examination in chief affidavit also.
Yes. So
So, what is the
what is the
difference between the two, and what is the legal value in front of the in the cases or in the judgments? Please
Yes,
mention
good.
this.
Good that you asked this question. So, what has happened is in civil cases, usually examination in chief is done through affidavit. So they call it affidavit in lieu of examination in. Okay, this does not happen in criminal cases, but there are certain exceptions. For example, Negotiable Instrument Act cases. So there is a specific section in Negotiable Instrument Act which allows affidavit to be filed. Okay. Now, as regards the advantage and disadvantage, see there I find more disadvantage than advantage in filing affidavit. What happens is in affidavit, you you are prepared. You are basically putting across your case in a prepared manner. You are coached, okay, by your lawyer. So there is no filter of a judge. So sometimes in affidavit, even irrelevant facts also come before the court. Therefore, what happens? Even the cross examination can become lengthy. The issues which are to be decided, like I am talking about the civil cases, usually what happens that plaint is filed, then written statements are there, then issues are now there. If the what are issues are the relevant things which have to be decided by the court. When you file affidavit in evidence, this is what happens practically. Everything and anything is put on record, which could be beyond relevance also. As against that, what happens before the court when the witness is examined in the witness box, that is, the chief is taken in witness box, the judge can, if the lawyer asks some question which is not relevant, the judge can stop the lawyer. That no, this is not relevant. I will not allow this question to be taken longer. So there is a filter. This filter is not available during affidavit. Now, I am not recollecting the name of this case, but there was an issue before Bombay High Court. I remember it was judgment of Justice Anuja Prabhu Desai, where in a domestic violence case, so usually affidavit in lieu of examination in chief is also filed in domestic violence case. So the party had challenged this. The husband's side has challenged this, that such affidavit should not be allowed, and the various grounds were raised. So that if you get an I am not able to locate remember the name of the judgment, but it was, I am sure, Justice Anuja Prabhu Desai's judgment. So that judgment you please go through. You will come to know about the advantages and disadvantages of. Ultimately, the court allowed affidavit in lieu of examination in chief. Okay, but that judgment discusses these different aspects of the advantages of affidavit, having affidavit, and not having affidavit. Okay, so that is how it is. But in IPC offenses, okay, strictly affidavit is not allowed in criminal case. Acha, I want to say that complainant might be first witness for his case. Yes, usually yes, but it is not necessary. Okay, it is not compulsory that witnesses must be examined in a particular sequence. It all depends on how the prosecution wants to strategize the case. If you notice, usually the investigating officer is examined at the end. The reason is because the investigating officer is expected to know the entire process. He has done the investigation. So if there is any lacuna left by any of the witnesses during the depositions, then the investigating officer, like through investigating officer, the prosecution can put proper questions and get that lacuna plugged. Okay. So if a particular document is missed, then through the IO, that document can get exhibited. So this is the reason why usually IO is examined, investigating officer is examined at the end. But there is no hard and fast rule about sequence of witness. It is all depends on strategy. So if there is one section in Evidence Act also, again I don't remember the now there is, because this new act has also come, there is confusion over the sections number, but there is a section with respect to number of witnesses. So there is no minimum requirement of number of witnesses or maximum requirement of number of witnesses. It is never that if there are 100 witnesses, that means the case is more foolproof, or if there are 10 witnesses, the case is less, less chances of conviction are there. Nothing like that. Okay.
In case of a murder trial, the victim's wife is being cross-examined, and the accused advocate is being very tough on her. Due to depression and pressure, the victim's wife is saying wrong facts. What can her advocate do in such a case?
I assume that her advocate, you mean to say prosecution. So, yes, if the lawyer is badgering, it is called badgering, sometimes to forcefully put words in mouth of the witness. Okay. Then in that case, the prosecution can object. The judge also, if the judge feels that, this is amounting to pressure tactics, then the judge also will interfere and say, please don't ask such questions or don't pressurize the witness, be polite. But I will tell you that badgering is also a tactic. Sometimes it is required to elicit truth. So, though it is on paper forbidden, but practically sometimes it is required. It is required. But to protect the witness, just to answer that question in very strict terms, to protect the witness from badgering, the prosecutor can raise objection. If the judge is not entertaining the objection of the prosecutor must say that record my objection and give a ruling on my objection. Sir, Panch should be eyewitness in Panchnama in criminal case. Panch
Okay.
should be eyewitness. No, Panch is not an eyewitness. He is like an attesting witness, or a witness who has seen the recovery in front of him, or who has seen someone signing in front of him. If some papers are recovered, say there is a case of forgery, some checks are forged, those checks are recovered from a particular. The intent of punch witness is to ensure independence. Okay, because therefore they say that punch witness should be a respectable member of from the society, because it gives a kind of independence to the investigation. So punch witness's role is that to ensure that there is independent validation of recovery, or independent validation of some signing of some document, like that. Yeah, maybe observer. I don't know whether observer he does observe, but basically it is to ensure that it was independently done. The seal, for example, a particular weapon is recovered, it is sealed in front of the punch. Okay, so sanctity, to ensure the punch can testify about the sanctity of that recovery.
So one more question from registration form. What is the process expedite a criminal trial in cases where the witness is also suffering from a life-threatening disease like cancer?
You can make an application before the court if the charge is framed and if you such kind of element is there, such an application can be made,
Okay,
and
sir.
it would depend on what the value of the witness, also how important that witness is for that particular case.
Yes, sir. So last question. Practically, how does video conferencing to examine witnesses work? Is it really happening or is it
So
still theoretical?
it is still theoretical. It is not happening except for cases of doctors. In cases of doctors, it is happening like expert evidence. Okay. In case of expert evidence, it happens. Like that is to save the time of the doctors, because doctors are busy. So, and in case of the doctors, the demeanor of the witness is also not that relevant, because as an expert witness, he is only supposed to depose with respect to his subject. So testimonies of experts are taken via video conferencing, but it is not becoming very common. But gradually, there is what I should say, some line of thinking is that where the witnesses are only for the purpose of mechanical purpose, or maybe technical witnesses, you can, rather than saying mechanical, it is only for technical reasons, then such witnesses can be examined online. Otherwise, then other witnesses are to be examined physically, because one has to ensure that they are not coached also.
Okay. Thank you so much, sir, for covering those aspects of examination of witnesses in such an intricate manner. It was a very enriching experience. Thank you
Thank,
so much, sir.
thank you, thank you.